I'm going to get the recording started. And, you know, Jim, here's how I think we should tackle it. Why don't I take the odd numbers and you take the even numbers? What do you say?
All right. Sounds like a plan. I am so excited that we're doing this because I think it would blow a normal person's mind. About a normal person, what I mean by a normal person is not a lawyer. How often there are so many problems when someone gets sick or passes away. And we see this stuff. I mean, it sounds almost trite to say we see it all the time, but literally we see it every day where people just don't pay attention to something that frankly was really important enough for them to do an estate plan, but then making sure you stay on top of it and keep it top of mind. Super, super important. I'm really excited about this content. So take it away.
Yeah, and I think one thing that a lot of people I meet with experience is when they have this estate plan, a lot of times it's dozens and dozens of pages of paperwork. I know when I drafted my first trust for me and my wife, I showed my wife, Lindsay, all the documents, and she said, "Oh my gosh, I can't believe how much paperwork there is in here. I thought it was going to be like 6 or 7 pages, and it's over 100 pages." So if you're anything like my wife, you're probably in the same boat, and you probably can use a little bit of advice to kind of decipher all these documents. So why are you here today? What value are you going to take out of this meeting today? Well, consider this a date with your documents.
So romantic, so romantic. A date with your documents. Really, isn't it romantic?
Yeah, I'll light the candles, and we'll have a great time. But what really should you be looking for in your documents as you go over, you know, those dozens of pages? What can you look for to determine if these are up to date? Now, I'm a lawyer and Jim's a lawyer, and we're talking about this legal stuff, but I don't want you to confuse what we're doing today as giving legal advice. So this is really for informational purposes. It's designed to get the brain juices flowing. And legal advice is really what happens when you sit down with a lawyer, you video conference or have a phone call or an in-person meeting with a lawyer, and we have a chance to kind of get to know your individual situation. And then we can deliver some legal advice. So even though today we're talking about 10 things that you can look for in your documents to kind of help determine if they're up to date or not, I don't want you to kind of watch the presentation today and say, oh, well, it looks like I checked off those 10 boxes and so my estate plan is totally up to date. I would highly encourage you to have a meeting with a lawyer to really make that determination. And you're actually in luck because one thing you get for joining our webinar today is the opportunity to, at the end of this, schedule a free, no obligation consultation with me or one of the other lawyers at the firm to go over this and actually receive some legal advice. So if you guys have any questions, we certainly want to answer them. We'll be doing a Q&A at the end. And on Zoom, there's the ability to type in questions into the chat section or the Q&A section. So we'll get to those at the end.
The Q&A section is the place where you want to put those. It's to the far right. That way we can check them off as being answered.
Yeah, awesome. We want to get you guys out of here by 5 o'clock today. So a little bit about the firm real quickly. So we have 7 lawyers here. You can probably see our faces on the screen, but that's Jim on the far left there, and that's me in the red tie. Jim, you've assembled a team of good-looking lawyers here. And these are the 10 red flags that you may want to identify as you're looking over your documents to kind of help determine if it's up to date or not. So without further ado, number 1, one of the first things you can look at in your estate plan with a trust is to see if there's a table of contents. That's a great starting place to look at to just kind of get a general overview of your plan, right? So as we go over these topics, if you have a trust with a table of contents, and we're talking about something like a trust protector, for example, you can look in your table of contents, see if you see that phrase, and that's a good indicator if your plan includes provisions for something like that or not.
And so just to be clear, you said trust protector. So trust, there's a trustee and all these other terms, but if you have something called a trust protector in your table of contents, that's an added feature that we'll be covering.
Yeah, certainly. So a table of contents is a good starting point, and I want you to look over your document, see if you have that. Not all trusts have a table of contents, but if you have one, that's a sign that it is maybe a more modern trust, and it's a little easier to navigate. And one thing that's really worth mentioning is, remember, one day something is going to happen to you. You're either going to get sick or you're going to pass away, right? And another person is going to have to pick up these documents and figure out what it says. Now, they're probably going to hire a lawyer to guide them through that process, but initially they're going to pick them up. They need to figure out what this thing says. And I think a good table of contents is a good starting point for those people to kind of figure out what's going on. So on to number 2.
Oh yeah. You know, people ask us, Jim, Jeff, how often should we be looking at our documents? How often should we, you know, blow the dust off, dig them out? The average estate plan in the United States is 17 years old. Now, if you do the math, 17 years ago was 2003. And I think we can all say that was a totally different world. So the average estate plan is 17 years old. 17 years for the vast majority of people, their family situation has changed entirely. Births, deaths, marriages, divorces. How many people get divorced? About half of marriages end in divorce. But as a general rule of thumb, we use 3 years. It's a nice round number, but 5 years, you know, sort of 3 to 5 years is a good gauge. If you're a business owner, and this is really important for business owners, if you're a business owner, if you don't have a buy-sell agreement, which you should consider, whether you have partners or not, but a buy-sell agreement says, hey, if my partner declares bankruptcy, what happens, right? Am I now a business partner with the trustee in bankruptcy, with basically a court official? No, a lot of businesses will have an agreement that says, if my partner becomes insolvent, then I pay him money, or he loses his shares, or she loses her shares, whatever the case may be. Those should be reviewed annually. So typically they're done when you do your taxes. It's a good task to add on there. And I do consider a buy-sell agreement a form of an estate planning document, because estate planning documents, what they address primarily are incapacity and death. So I have a trust written in 1998. It's the Cunningham Living Trust, dated March 20th, 1998. My wife and I have restated the trust 3 times. Now, what does that mean? Well, that means that our son was born, we did an estate plan. We then adopted our 2 daughters. They then did not, the world changed, things changed. People turned out differently than you might have hoped or thought or dreamt or whatever. And that applies to trustees. And so we have changed our successor trustee. We've changed the way my children are going to inherit. And we'll talk a little bit about that. But an amendment and a restatement, an amendment changes a page or a paragraph or a couple of pages. A restatement takes the whole trust and throws it out and replaces it with a new trust. And I will tell you, most skilled lawyers all agree that it's a best business practice or a best legal practice to do a restatement. And so that restatement restates your original trust.
Yeah, Jim, I would say in my experience practicing, more often than not, I have a potential client sitting in front of me, and they bring in all their documents, and they don't even really tell what the date of their trust is, right? They've done 5 different amendments, and they don't actually know what the trust itself says, right? And when you have all these successive amendments, you have to piece them all together to figure out what the trust says. So doing a restatement of your trust really becomes a worthwhile endeavor, because it takes all those amendments and consolidates it into one document. So
we have
one thing you can do at home.
Yeah, we have a question.
Yeah.
Hey, can we create a table of contents if it wasn't created originally? Word, the application Word, you probably don't have your documents in Word format. You can actually auto-create a table of contents, but absolutely. It's laborious. It's, the sphere of technical writers, but you absolutely, if you got your master's in English, go for it. Make your own table of contents. Those are made when we create a new estate plan, a restatement, or an original new trust. You typically don't see them on amendments. You typically only see them on the original trust and the restatement. But yes, you can create your table of contents after the fact. Absolutely.
Yeah, that's a great question. So the third thing that you can look at in your documents that may trigger a red flag is, frankly, look it over, see who you've named in all these different positions that people are going to hold, and just determine, has anybody passed away, right? That's a picture of Jerry Stiller, the legendary actor. He's Frank Costanza on Seinfeld. He passed away yesterday at the age of 92. But it's not uncommon for people to have other people who are named in their trust pass away, right? And whether it's your successor trustee, maybe you've named a sibling who was older than you, and they just happen to pass away before you, or maybe a beneficiary passes away. I had a client I met with recently who one of her sons passed away before her, right? People sometimes they die out of order. And the trust had a provision that discussed what happens if one of her children passes away, and it said that it went to her grandson. And the problem was her grandson was in the third year of a 30-year prison sentence. Ooh. And if we hadn't looked over that trust, if we hadn't identified that someone passed away, that could have been a really bad situation if a really large inheritance was going to that person. And we talked to the client about it, and it turned out that that wouldn't be what their wishes were. So that would be one tip for you guys at home as you sift through your documents. Just see, hey, have I named all the appropriate people here, and has anybody passed away? And I would say one other thing on this one is a lot of people, especially married people, usually will have a joint trust, right? They are both spouses are the owner of the trust. And if one passes away, that's a trigger that work needs to be done. You need to look at that trust and work with a lawyer and make sure you're administering the trust properly. So that's a helpful hint. And if you're a person who's sitting there saying, hey, I do have a person who passed away, but I don't think it's that big of a deal because I've named people after that person, you may want to consider updating the document to remove the name of that deceased person, because what's going to happen is when something happens to you and that trust or that power of attorney or whatever the document is needs to be administered, all of the banking institutions, the escrow company, the title company, they're going to see that name of the deceased person, and they're going to say, well, hey, we want to work with this person. And the next person in line may have to go through a big chain of events to prove that that person's passed away before they can actually take over control of the assets. And in some of these instances, time may be of the essence. And if they need to spend valuable time proving that person's passed away, that could be detrimental to the administration of the trust.
Yeah, Jeff, that's something I cover in the book. And I'm showing this here today, Savvy Estate Planning, what you need to know before you hire the right lawyer. It's on Amazon. If you just put in Amazon Savvy Estate Planning, you can see that. It's available for purchase on Kindle and on paper. But one of the things that I wanted to mention is we're talking about a living trust. But for many clients, a significant portion of their estate does not ever pass through their living trust. And what I'm talking about are 401ks and IRAs and life insurance and annuities. Those oftentimes pass by beneficiary designation. So what that means is if you get a policy of life insurance, the life insurance agent is going to ask you, well, who do you want to receive the proceeds from the life insurance? So when you die, who gets the money? And you got to pick someone. Well, when the time comes when you've passed away, if that person is passed away, literally the $64,000 question is who gets the money? And you typically don't look at your living trust for that, but you look at the internal procedure at each institution. So if you have accounts at 5 different institutions, you theoretically could end up with 5 different outcomes. So it is very, very important, not only pay attention to your living trust, but also pay attention to things that pass outside of your living trust. And again, go to an expert lawyer. This is not a do-it-yourself project. We are administering a trust that's a do-it-yourself project. The fees literally are 20 times what they would have been if the guy would have just done a living trust with a lawyer. I mean, I think they passed $100,000 to administer the trust. Because it's a disaster. Multiple rentals, terrible. The two lawsuits pending when the guy passed away. So very important, pay attention. When someone passes away, that's a great time to just check in with an expert lawyer and ask that lawyer, hey, is there anything I need to do?
Yeah, great advice, Jim. And the fourth topic, which I'm going to ask you to talk about, Jim, is reviewing your trustees. So this is similar to the prior topic of looking to see if anybody's passed away. But Jim, hopefully you can elaborate on how important reviewing your trustees are in your estate plan.
Yeah. So here I'm just going to rattle off some issues that we see. Number one, many people name one trustee. That's it. I'll name my wife to be my successor trustee. Okay, great. And then if she doesn't serve, I'll name my oldest child. Why the oldest child? It's the honor of being the oldest child. And they may not be the best. I mean, they might be the best person, might not. But what we see many times is people either aren't living when it comes time to be trustee, or for one reason or another, they just frankly don't want to do it or can't do it. And I remember a story. I met with a client years ago, and I was talking to her, and she said, I've been successor trustee for 3 different family members. And I think she was over 70. She says, I don't want to spend the last years of my life being trustee for somebody else. And I don't want to put that on the person I originally thought I wanted to name as trustee. I'm going to name somebody else. So it's very important. It's good to have a backup plan. It's really good to have a backup plan. And it's always good to think about listing more than one successor trustee. So you start out, if you have a living trust, you start out as your own trustee. What we're talking about is when you stop being trustee. So if you become incapacitated, unable to handle your affairs, that's when the successor trustee kicks in. Certainly when you pass away, that's when the successor trustee kicks in. Also, it's important to look at age. Now, I'm not saying that there's a direct correlation between age and essentially cognitive ability or desire, but many times people reach a certain age and they do have cognitive decline. So it's very important to think about. So many times people will say, well, I named my brother as successor trustee, and I'm 90 and my younger brother's 89. And we have the conversation of, well, it might be a good idea to name an alternate after your 89-year-old brother. Also, state of residence, very, very important. Trusts are wonderful planning tools. One reason is because they're outside of the court system, right? They exist outside of the probate court. So if you have a will, you have to go through probate. And if you do a living trust, you opt out of that probate system. Now, right now, we're under the COVID-19 court closure. We have, Jeff, I don't know, how many probates do we have backed up? It's like a traffic jam of probates. I think we have a dozen probates that we haven't yet been able to file the initial paperwork to even get the process started because the courts are closed. So, state of residence, why is this important? If you're a California resident, now we're in California, and you name a Massachusetts successor trustee who steps in and is trustee, what court is going to hold the trustee accountable? Is it the California court? Is it the Massachusetts court? I don't have an answer. It depends. Of course, that's a lawyer's answer. Generally, though, it's the state of residence of the trustee. And don't even get me started if you name a foreign trustee. You know, if you name a trustee who's a resident of Israel, how does that even work? And by the way, if you want to name a foreign resident, you're going to have a real problem naming, or a foreign successor trustee, you're going to have a functional problem because a lot of documents need to get notarized. Very important. If you're in California and you name somebody else as successor trustee out of the state of California, the tax rates are all lower with the exception of New York City. The residence of the trustee, if you're a California resident and you're the successor trustee of a Nevada trust, that Nevada trust is subject to California state income taxation, even though no asset is in California and the trust was created under Nevada law. Because California, like many other states, says that if you're a fiduciary of this trust, any income that is not distributed has to be paid to the, you got to pay tax on that to the state of California. So really, really big deal. And we have a question from Deb. Can't I just cross through the trustee that I no longer want to act and handwrite the new person in the margin? Here's what courts have ruled. When you strike the name, when you cross out the name of the person, that is a revocation of the appointment of trustee. And the handwriting, writing in a new name, is not an effective appointment. Courts have ruled that. So you actually are worse off than not having crossed the name out, because now you have to go to court and have a trustee appointed. So, you know, and I'll tell you, this is the reason you want to hire an expert, and the reason this is not a do-it-yourself project, and this is very important. It is, if you look at something that's technical, I think a lot of smart people can know if it's right or not. They know if it's correct, meaning if you do an estate plan with Jeff and Jeff puts in your brother's successor trustee, you can look at that and say, yes, that's correct. Where an expert really comes into play is knowing when it's wrong, right? So if you cross a name out and write in another name, you may think, well, that looks fine, that's what I want. But it's the expert who's going to look at that and say, no, it's wrong, that won't work. So thank you very much for that question, or Deb. Appreciate it.
Yeah, and Jim, I really think you hit the nail on the head there. And one thing that I see very frequently is people come in, like you said, they've named their kids to serve as trustee, or maybe they have them in a particular order. And over time, their kids have kind of spread out, right? A kid has moved to New York. My little brother, he grew up in California, and now he lives in New York. It's not uncommon for that to happen. So keeping a constant eye on this and acknowledging that as time goes on, things change. You need to continue looking at these documents over time to make sure they're appropriate in light of what your goals are. So the next thing here is a durable power of attorney. Now, I have no doubt that almost all of you watching today have heard the phrase durable power of attorney, and durable power of attorney for financial management is another way people say that. And this is essentially a document that allows you to appoint an agent to manage your financial affairs if something happens to you, if you become incapacitated and you can't do it yourself. A lot of people don't know what that word durable actually means. And what it means is a durable power of attorney endures you becoming incapacitated. So, for example, I name my brother to be my agent under power of attorney. Well, if that's not a durable power of attorney, the moment I get sick, my brother's no longer my agent under the power of attorney. He needs to be a durable power of attorney so that even if I'm sick, he can manage that. So if you're looking at your own documents, kind of evaluating them, look for that word durable. If it's a general power of attorney, it may not contain that feature. And from an estate planning perspective, in most instances, we want it to be a durable power of attorney. So some other things that you can look at with this document is also look at the date of this one. So I would generally recommend that you consider having your power of attorney updated probably about every 5 to 6 years. That's probably a good starting point. I've even seen powers of attorney drafted by lawyers pretty recently that have expiration dates on them. So you may want to look for an expiration date on there as well. And one of the problems that exists with these, if they're not kept up to date, is you get sick, your agent or your power of attorney needs to go to the bank to handle a transaction for you. Perhaps they need to help manage one of your retirement accounts, for example, that may not be part of your trust. And an institution may look at it, and if you signed it too long ago, if you signed that power of attorney 10 years ago or 12 years ago, the institution may not even accept it. So as you're looking over your documents, keep an eye out for that. You also may want to scan the document over and see if you see any language regarding gifting authority. This has become a really important thing. So one strategy a lot of people use is when they get towards the end of their life and they can't live at home anymore, it becomes extraordinarily expensive to go to a skilled nursing facility, for example. One strategy some people utilize is they try to get qualified for a government assistance program like Medi-Cal. Medi-Cal is California's version of Medicaid. And sometimes people end up, they are, too wealthy on paper to qualify for those programs. One thing an agent under a power of attorney may be able to do is gift those assets to a strategically crafted trust so that person can become eligible for those benefits and at the same time preserve that wealth and that trust that they've worked a lifetime to accumulate. So a durable power of attorney, very important document, very important that one remains up to date.
So there's a question here. Are there any jurisdiction issues with an agent under durable power of attorney, gifting powers, or other financial decisions like there is with a successor trustee? Yeah, there is. But you don't have this wrapper of a trust. So if you name an agent, so you're a California resident, and you name your brother who's in New York, I don't really see a problem with that, okay? I mean, apart from time zone, because a New York resident agent, if they need to notarize a document, and by the way, just back up, why do we even have a durable power of attorney? This addresses everything that's not inside of your living trust. So many of us have a home. Well, the home goes in the living trust. Many of us have an IRA or a retirement account. Well, that does not go into your living trust. So if I have a stroke and my wife needs to withdraw money from the IRA, she's going to use my durable power of attorney. But again, the agent under the durable power of attorney many times will have to have documents notarized or acknowledged before a notary public. Now, if you're within the United States or a United States possession or territory, pretty straightforward getting a document acknowledged. if you're outside of the United States, many institutions require essentially an American notary to notarize the documents. So if you're in Canada and you can't hop over the border to have things notarized, you may have to go to the embassy or the consulate, which I can tell you is literally an all-day project to go to an American embassy or a consulate anywhere. They're always on lockdown, and especially now with all the health precautions. So best practice, name an agent, the person who serves under the durable power of attorney. It's better if they live in the United States or they have access to a notary public easily.
Certainly.
HIPAA authorization. So this is really important. Many clients come in and we dust off the estate plan, and guess what? The estate plan is from the 1990s. Well, there was no HIPAA in the 1990s. And what HIPAA is the medical privacy. So we all know when we go to the doctor's office, they say, you know, Jeff, you go to the doctor's office, they say, Jeff, now we want you to sign this document. And what this says is we're telling you we're not going to release your confidential medical information without your consent, but we want you to sign this to let you know that we've told you that, which to me, I'm like, this is a complete waste of time, right? I don't know why they're doing this. I think it's to be HIPAA compliant, but the healthcare people, the people who are subject to HIPAA, are very concerned about HIPAA violations. The fine is $50 to $50,000. That's the range of fine. So they're very concerned about it. And frankly, they want to keep your medical information private. Well, here's the problem. When HIPAA was written, if I go to my wife's physician and I don't have a writing from my wife that says I can access her medical records, which is what a HIPAA authorization is, they're not going to tell me anything at all, period, end of story, right? So I think we've all been there where we're trying to get health information. This becomes really important if you have children who are going off to college. I mean, I guess they're going to college. I don't know. Hopefully in the fall they will. But if you have a child who turns 18, you are not going to be able to access their medical records. And when it comes to reproductive rights, even women under the age of 18, there are restrictions on parents accessing health information when it comes to reproductive rights for minor children. How do we solve this problem? How do we solve this puzzle? Well, we counsel our clients to consider a HIPAA authorization. So this is a list of people who are able to make who are able to access your health information, not make healthcare decisions. So for example, I've named a trust company in Nevada as successor trustee of my trust to save income taxes for my family when I pass away and they inherit. I've named the trust company in Nevada on my HIPAA authorization. Now, why on earth would I do that? Because they may need to get a death certificate, right? They may need some confidential medical information if I become incapacitated and my wife becomes incapacitated. So they may need to do their job as successor trustee. So we've actually put them on our HIPAA authorization, as well as each of our children, my parents, you know, so it's a broader scope of people than just the healthcare decision-making people. You know, I don't want a bank trustee making healthcare decisions for me, but I certainly want to have the bank have access to my health records in order to facilitate the trust administration process.
Yeah, and Jim, as you know, a HIPAA authorization is not the only document that goes in an estate plan that's related to healthcare. So typically you'll have a healthcare directive, an advanced healthcare directive. You may have a document called a living will. But the reason that I decided to put a HIPAA authorization in particular on this slide is I review a lot of estate plans. I mean, I probably have, you know, I meet with a dozen people per week and I review their documents. And the HIPAA authorization is probably the one that I most consistently see missing from that pile of documents. So even though this was enacted in the mid-90s, it was signed by Bill Clinton when he was president, I still see a lot of estate plans that are drafted in the 2000s era where they neglected to have this document. So very important to have that. If you're looking through your stack of documents, see if you can see that acronym HIPAA. And that's if you don't see it, it's a good indication that you probably want to consider having one. So at the very beginning of the presentation, we mentioned something called a trust protector. What on earth is a trust protector? I call this the superhero feature. And most practitioners today say if you're going to create a trust, you really should consider having a trust protector in there. So what is a trust protector? Before I talk about what it is, I like to talk about the problem it's trying to solve. So for many of us, the statistics say that at some point before we pass away, we will likely become disabled or we will become incapacitated. And when you become incapacitated and you have a trust, typically from the point you become incapacitated, your trust becomes irrevocable. It can't be changed. And if you think about that law, it's a good one, right? We don't want people modifying their trust if mentally something has happened to impact their judgment. But at the same time, what happens if the owner of a trust has become incapacitated and before they pass away, the law changes, right? Maybe the tax code is changed or something that makes the provisions of the trust outdated. Well, what position does that put the beneficiaries in? Really not a good one, right? They stand to receive a future inheritance from a trust that's become outdated. Maybe this new tax law is going to impose a new tax on their inheritance. And if they could just modify the terms of the trust, they could provide relief from this new law. Now, typically what people would have to do in that situation is hire a lawyer, go to court, and maybe 8 months later, a judge may grant them the relief they want. It may cost them $10,000 or $15,000 in legal fees to accomplish that. The modern way of solving this problem is by putting language in your trust for something called a trust protector. And this is a person or an entity who you can name in your trust to solve this problem if it ever comes up. A lot of our clients, Jim, they name our law firm to serve as the trust protector. So they name CunninghamLegal to serve as trust protector. And this gives us the ability to work with the beneficiaries in a situation like that and make a small tax-based change to the language of the trust to alleviate the impact of that new law potentially. Yeah. One other thing, a trust protector. Oh, go ahead, Jim.
Well, I was just going to say, you know, we had a situation a couple of years ago where a client owned a ranch in Northern California with his parents. So they were 50-50 owners. The son was 50-50 owners with mom and dad. And the trust said that mom and dad want this half of the ranch in Northern California to go to the one son. I mean, it makes sense. And everyone in the family was like, great, it makes sense. Well, what happened is in between the time that the parents came in to visit with us, the son and his parents sold the ranch in California and bought another ranch in Texas. And then the parents died, but they never updated their estate plan. And so the way the documents read is that the gift of this half interest in a ranch in California went away when the parents sold the ranch. So this is something else to think about. As you buy and sell property, if you've made any particular provision for a certain piece of property for an individual and you sell that property and it's no longer in your trust when you pass away, there is a consequence to that. Now, I don't know what the consequence is, but in this particular case, the son who wanted the half of the ranch, right? And now this other half of the ranch is in Texas. They come in and they say, listen, these documents need to be rewritten. Well, in order to fix that, the trust protector changed that provision. Everyone agreed. They modified the terms of the trust. If you don't have a trust protector, that likely would have required a court action in California and probably Texas as well. So it wouldn't have been 15,000. It might have been 35 or 45,000 just to fix one provision in the trust. And people, you can't ignore what a trust says. If a trust says go left and you decide to go right, you really can't ignore that. And so another way to think about a trust protector is a trust protector has power over the trust, but isn't the trustee. So a trustee has to follow the terms of the trust, but a trust protector, provided everyone agrees, right? A trust protector can change the terms of the trust or provide a different or change a provision, right? So.
Yeah, and this is one of those things that you can look over your documents and you can see if you see the language trust protector. Sometimes this is referred to as a trust advisor. And if you don't see this language, you may strongly want to schedule a meeting with us, because I would say most modern trusts that are well drafted are going to have some kind of safety component like this in there.
Okay, so when I started practicing practicing law in 1994, and a married couple came into the office. Pretty much everyone got an AB trust. Now, what is this? Here's the bottom line. It used to be that if you were married and you wanted to double up on your exemption, now what that means is that's kind of like a coupon. So it used to be 600,000. I don't know if, you know, many of you, I actually recognize some names here. I think I might have met with some of these people in the 90s. But if you have a living trust and you did it when you were married, while this rule was out there, in order to double up on your exemption, so in order for a married couple to leave 1.2 million free of estate tax, they had to do this structure of an AB trust. So otherwise you could only leave 600,000 in taxes. By doing the AB trust, you actually saved about $235,000 in estate taxes. That's fantastic. Now the rules are totally changed. 99.99999% of families will never pay any estate tax. But we literally have, Jeff, it's probably in the millions of B trusts out there. Now, here's why this is important. If I buy something for $1 and it goes up to $3 in value, and my wife dies, if it's community property, which it is, so I buy something for $1, it goes up to $3, it's community property, my wife dies, I can sell that thing for $3 and not pay any capital gains tax. So when Steve Jobs died, his widow sold, I think it was about $450 million in stock. It was either Disney or Apple. I can't remember which one. She saved about $150 million in capital gains taxes, okay? This, folks, this is a huge deal. If you're married and you have rental property and you've depreciated, when one spouse dies, if it's community property, you get a full adjusted cost basis. So it's a very important term, adjusted cost basis, huge tax savings. All right, so let's say that my wife dies and that $3 asset ends up in the B trust. And then it goes up to $6 and I die. My kids, when they sell that for $6, have to pay tax on the $3 gain. If that $3 asset that becomes $6 goes in the A trust, they get another adjusted cost basis. So they get another step up in basis, so the kids never pay any capital gains tax whatsoever. This is very important for people who own real estate. So real estate, a rental, especially investment real estate, residential or commercial, because that property is depreciated. Now, whether you choose to depreciate it or not, the government is going to force you to depreciate it. So if you own property and hold it for a long time, not only hopefully does it go up in value, but the tax basis goes down. So it is very, very important. If your trust was done prior to 2013 and you did it while you were married, there probably 50% probability it's an AB trust or an ABC trust, which is a different variant. If you did it before, and these are the years when the law changed. If you did it before 2009, much higher probability. Before 2001, Jeff, I think literally it was like malpractice not to do an AB trust for a couple. Yeah. So vast majority of clients did it. Now, what if you had a spouse who's already passed away and you're a widow or a widower and you're stuck with a B trust? What do you do? Well, last year, I think we did about 50 petitions in court to terminate the B trust, to get rid of the B trust. Now, this is after, so this is not while both spouses are married. If both spouses are married, you do a restatement. Do you remember that from item number 1, as we talked about a restatement of trust? So if you have a spouse who passed away and you have created this B trust, there is a way to terminate it. And Jeff, we've met with so many clients where we're saving the family. The capital gains taxes in California, folks, are 37.1%. 37.1%. It's 20 federal, 13.3 state, because California doesn't have any capital gains tax. It's all income, plus 3.8% net investment income tax. That's the Obamacare tax. That's 37.1%. So bear in mind, this is a huge tax. So we'll meet with families. We'll meet with the surviving spouse and the kids, and they may have $1 million baked in gain on that B trust. So meaning assets went in there and they've gone up in value and been depreciated. Actually, if you recapture depreciation, it's a higher rate. But in many instances, we're able to save families $200,000, $300,000, $400,000, $500,000 in capital gains taxes. It's fantastic. So if you're stuck with a B trust or you think you might have an AB trust, please reach out to us and we'll be happy. Yeah, Deb says, that's not fair. Well, yeah, I mean, it's death and taxes, you know. It's this is all fiscal policy, by the way, and this is very important. Taxation is about raising revenue. There's very little social policy built into our current federal estate tax structure.
Yeah, and usually when I have a conversation with somebody who's aware of this concept of a B trust or an irrevocable trust, one of the main questions they ask is, well, how on earth do I know if I have that style of trust, right? Well, I think the best way to find out is to have a qualified lawyer look over your documents, right? That's really the appropriate person to make that determination and discuss it with you. But I think if you're looking at your own documents and you just want a small, tip, how can I determine if there's a possibility I have this style of trust? Key language to look for is B trust. Sometimes a B trust is referred to as an exemption trust or a bypass trust or a credit shelter trust. Sometimes a deceased spouse's trust. So if you're looking over your older trust and you see that language in there, it's a good indication that you have that style of irrevocable trust. And I wouldn't say that AB trusts are completely inappropriate for everybody. They still serve a utility for certain people, but the segment of the population that those style of trusts remain appropriate for has shrunk considerably to where I would say, as a general rule of thumb, for most people, that style of trust is now inappropriate from a tax planning perspective. Jim, if somebody sees that they have a generation skipping trust or an irrevocable life insurance trust, what on earth does that mean and what should they know about that?
Yeah, so a generation skipping trust is a horrible name because it implies that it's skipping somebody, but actually what it is it's skipping the generation skipping transfer tax. It is skipping a tax. Now, what happens is if you have a wealthy family, wealthy mom and dad, they leave a lot of assets to a child and poof, that child's wealthy. Well, when that child dies, you're going to have to pay estate taxes again. So what a lot of people have done, and when I say wealthy, it used to be the generation skipping transfer tax exemption amount was $1 million. Now, $1 million when I started practicing in the 90s was a lot of money. $1 million now, I don't know, not as much. I see a lot more people, a lot more millionaires out there, right? But what a lot of people did, a lot of wealthy families, is when someone passed away and sometimes when they're alive, they would put assets for the benefit of a child into what we call a generation skipping trust, so that when the child died, the grandchildren don't have to pay estate tax, don't have to pay a death tax. That's a generation skipping trust. The problem with a generation skipping trust, it's the same problem that a B trust has. You don't get an adjusted cost basis on the assets inside of the generation skipping trust. Now, to put this into context, our capital gains tax rate is 37.1% for Californians. The estate tax rate is 40%. The estate tax rate in 1982 was 77%. 77% was the highest estate tax rate in 1982. Now, what we have to understand is law is very, very slow moving. People are trained to identify estate tax as an issue. Estate tax for basically everyone, except a very small number of people, is no longer an issue. It's just gone. So now what we're looking at is income tax and we're looking at capital gains tax. So what made these trusts efficient to avoid a 77% tax causes them to pay a 37% tax. You guys following this? So if the estate tax exemption were lowered again and we end up with the 77% tax, we'll be looking at a lot of generation skipping trusts in order to save that 40% difference on the tax rate. But right now, that's not the situation we're in. Life insurance. Okay, life insurance, not taxable as income. So if I have a life insurance policy of $1 million, I leave that to my wife. I leave that to my kids. They don't pay income tax on that money. However, life insurance is included in my taxable estate. Now, right now, I'd have to have over $11 million because that's the exemption, $11,580,000 per person. So my wife, and I can leave my wife $1 billion and not pay any, don't tell her that, but I could leave her $1 billion and she wouldn't pay any estate tax. I don't have $1 billion, but there's an unlimited marital deduction unless you're not a citizen. So life insurance passes free of income tax, but is subject to estate tax. So back in the day, what a lot of people did, if you had a $3 million estate and you were married, that's $1 million estate tax bill. And you'd have to pay that on a $3 million estate. I mean, there are a lot of people in West LA that have a house that's worth $3 million that they paid, $30,000 for. So what people used to do is they would set up an irrevocable trust, a life insurance trust, and they would give money. They would put money into that trust, and the trust would buy life insurance. By doing that, it took the life insurance out of the taxable estate of the parents in this case. Great result. The money passes tax-free. The money's available there to pay the taxes. Everything's good. Well, what's happened since a lot of people took these out is the cost of insurance has gone down not once, but twice. Now, what do I mean by this? When you buy a policy of life insurance, they assume that people will live a certain number of years. They used to assume that you would live 100 years. Now they assume you're going to live 105 years. That has the net effect of making life insurance cheaper. Fewer people die, fewer death claims. The insurance cost goes down. We had one client come in last year. They had a $600,000 death benefit, $60,000 cash value, and a $6,000 a year premium. So if they die, their kids get $600,000. It had a cash value, so it was a permanent policy, a cash value of $60,000, meaning they could say, I don't want this policy anymore, give me my $60,000. But to keep the policy in effect, they had to pay $6,000 a year. Well, we were able to work with Ascent Wealth Management, and the client was able to do a tax-deferred exchange so that they kept their $60,000 cash value. They were able to keep their $600,000 death benefit, but the $6,000 premium went away. It's because life insurance got cheaper. So that's what it means. Your premium goes down. Clients were very happy. They were very excited. They could now take a trip to Hawaii every year on the money they would have otherwise spent on the life insurance premium. So a very good result.
And I would say I'm so happy that we're recording this because, Jim, in about 6 minutes, you summed up a year of law school. So, so well done. We're going to show this to young lawyers, and hopefully they gain some value out of that. So what's another thing you can look for? We're getting towards the end here. Handwritten notes. I can't tell you how frequently I see this and what a huge problem this creates for people when it exists. So this comes up in a variety of different situations, right? So sometimes I meet with people and they bring in their trust. They say, Jeff, this is a really old trust, but don't worry, it's up to date now because I crossed out all the old stuff and I hand wrote new stuff in there, right? That is a potential disaster. I think this same scenario kind of comes up a little bit differently where somebody tries to handwrite or hand type their own amendment. I have a ton of people I meet with where we need to correct that problem. And one issue with doing that is I think a lot of people kind of have a mentality when they look at their documents, to the layperson, to a non-lawyer, they look at it and they say, well, hey, this is English, right? And I know how to communicate in English, so I can very easily make a modification to this and express what my wishes are. And I think to a degree, yes, you can, but there are so many things that the lawyer is evaluating when they put these documents together. And you may have no idea that those even need to be evaluated. You may not know that this particular language needs to be at the end of the document or else the whole document is ineffective. So I would say if you look over your documents and you have handwritten notes on there, that is a key indication that you should really consider coming in and meeting with us, and we can evaluate that for you and make sure you're not going to leave your family with a big mess. I would say that none of what we're kind of saying today is like general, you can take this to the bank legal advice, but I will say one thing is that if you're looking at your documents and you see handwritten notes on there, that is almost a given that you really should come in and see a lawyer to review that. Jim, I think we had some clients before who they were leaving a pretty large, they had a pretty large estate and they were leaving it to 4 different charities. And before that person passed away, they took a pen and they crossed out one of those charities and then they passed away. And the question was that a valid amendment to the trust, right? Are there only 3 charities who are entitled to it, or is that 4th charity that got crossed out still entitled to it? Now, that's a whole legal equation that needs to be solved, but the result is those charities were fighting probably for years over who's entitled to that, and it created a huge problem for the family, and we want to avoid that, right? We are your guides to make sure when something happens to you, everything goes smoothly, and you want to avoid those handwritten notes, probably at all costs.
Here's the bottom line, and what Jeff is saying is he's talking about probably the most basic foundational question that a judge is going to ask himself or herself. And the reason I say a judge is if there's a dispute, you don't get a jury trial on a trust. Doesn't happen. It's going to go in front of a judge. And a judge wants to honor the intent of the person who created the trust. So really, it's the judge's job to look at all of the evidence and say, what's reliable, what's not reliable, what did this person really want? And the problem with a handwritten document is it really, it can cause confusion. It can cause, if the document is not written a certain way that a judge is used to seeing a trust amendment written, the person who's creating the trust or creating the amendment may not be effectively communicating, right, what their intent is. So you can really end up with some crazy results. So there's a question here. Ralph writes, how do you add grandchildren to inherit assets if they were not born when the trust is created? So if everyone's alive, meaning, let's say, Ralph, if you said, hey, I want to add grandchildren, how do I do that? Well, you can amend your trust. And, oftentimes it's a restatement. So you can sign a document. So one way to do is you can sign a document with a lawyer. Another one is something called a power of appointment. Now, this is maybe a little down in the weeds, but sometimes if you're the beneficiary of a trust, you have the power to appoint the property to somebody else. Now, what that means is the power of appointment is best described as the power to disappoint. So my parents can leave the property to me in a trust, and I'm the trustee of this trust, and it's protected from creditors and divorce, and life is good. And the trust says when I die, it goes to my children. But if I don't want to leave it to my children, and I'd rather leave it to my grandchildren, I can sign a document called a power of appointment. This is not a form. This is a document an attorney writes up. And my power of appointment disappoints my son, right? Because I've appointed the property to my grandchildren now. So those are the two big ways you would do it. But what I'm getting from the context of this question, Ralph, since I'm assuming you wrote this and you're alive, go ahead and amend your trust. That's how you would add them.
Yeah, that's a great question. And so, Jim, the last one you touched on briefly towards the beginning, but is it problematic if somebody was working with a lawyer who drafted their trust and they're not meeting with that lawyer frequently, or they just haven't heard from that lawyer since they did the trust? Is that problematic?
Well, yeah, I'll tell you. Here's how the real world works. I've been a lawyer for 26 years this year. I talk to a lot of lawyers across the country. Most lawyers, when they handle a case, it's over. It leaves their mind. They move on to the next matter. They move on to the next client. Many very good lawyers don't pay sufficient attention to their existing clients. And that's something we really try to do, is we really try, this is one example. I recognize names. I recognize names. I've worked with some of these names for over 20 years. It's amazing. But I think lawyers in general, it's not that we're lazy. It's not that, maybe it's the shiny new object, but it also requires a level of organization and structure that frankly is not most lawyers' best trait. They're not technology people. They're not, constantly reaching out to their clients, or even every 3 years. I do see a lot of lawyers, though, will write a letter to their client once every year, or once every 2 or 3 years. But, we've taken over. We've acquired 18 law practices now, where lawyers have just sort of raised their hand and said, you know what, I'm done. I'm going to retire. And we've done that now 18 times. And what we find is that we send a letter out, because the law requires us to send a letter out. And many clients, they say, this is the first time I've ever heard from my lawyer, and I did my estate plan 15 years ago, and I've been thinking about updating it for 5 years. Thank you so much for reaching out to me, and we're able to help them. But here's the deal. It used to be, I would say, 3 years, 5 years, it depends on your situation. We have had so much change in the world in the last 3, 4 years, 5 years. Going back to 2017, that was a massive change in the law. And we've had the Secure Act, we've had the CARES Act. You don't have to take a minimum distribution this year if you're subject to required minimum distributions. A whole bunch of stuff has happened that really has changed the landscape. And, you know, the whole point is, look, it's taken you a lifetime to create what you've created. You want to leave it to the people that you love. You want to make sure it's not messed up. And our firm, we offer a free review, a free consultation. Why wouldn't you take us up on that? I mean, that's, I don't understand why people wouldn't want to do that. In fact, most do. And, you know, if something needs to be updated or changed, then we talk about it, what that looks like, and if there are any fees involved or not. And, you know, sometimes they're not, Jeff. I mean, sometimes we say, hey, you know, I see your IRA beneficiary designation is with Wachovia. Well, Wachovia went away about 10 years ago, right? Maybe 12 years ago, and they're now Wells Fargo advisors. So our advice might be, gee, you might want to check with your advisor and make sure that, you know, your kids are named as the beneficiary of your IRA. And I say that because we did have one case where Wells Fargo couldn't find the beneficiary designation because all the paperwork didn't make it over. I mean, it was kind of chaos in 2008. So it's very, very important to kind of ping your institutions and just ask them. I mean, this is kind of a cool homework assignment, but you know, call your financial advisor, call your, you know, and if you have to call the 1-800-NO-HELP number, right? So if you're with one of those companies that doesn't have an advisor associated with it, reach out to them and find out who are the beneficiaries of your IRA and your life insurance and all this stuff. I mean, that's something that's really important to pay attention to. I do want to mention the CARES Act. The CARES Act is a really, really big deal. It's the single biggest stimulus that's been put into the economy. China has done one. Japan has done one. Europe's doing their own form of it. But there is a lot of stuff in there about trusts and estates. And I want you to know that we're really paying closely attention to it. Please pay attention to our emails as they come out, because we are, as the laws change, we're doing these webinars to keep our clients in the loop.
Yeah, thanks, Jim. And one thing I just want to say is how proud I am of our firm that we do this. So as I'm looking at the kind of attendance list right now too, I see a bunch of clients that I've worked with over the years. And I'm just so happy that we do this ongoing education for our existing clients. We actively reach out to our clients to bring them in every 3 years. So if they haven't heard from us, we're going to send them a postcard. We're going to get them in for a free review. And frankly, sometimes you come in for a free review meeting with your attorney, and sometimes nothing needs to be done, right? I think yesterday I met with one of my clients who did all their documents about a year ago. And the circumstances ended up being that their documents were fine. Now, on the other hand, later this afternoon, I have a meeting with one of my former clients from about 3 years ago. And I've been looking over his documents. And over the last 3 years, there have just been such significant changes to the law that we're certainly going to be updating some of those documents. But the fact that we do that with our clients, I think that unfortunately, the lawyers who aren't doing that with their clients, they're not going to have a client base of people with successful estate plans. And that's a shame. And that's really what we're all about here. So frankly, guys, for 1 hour, I know that's a lot of information to digest, right? Your brains might be full at this point. What we're going to do is we create content like this all the time. And so the best way to find more of our content is by going to our website and registering for more events like these, more virtual workshops. And you can also go on our Cunningham Legal Facebook page, where we post recordings of the previous videos we did, and we have new content every week. So next week, we have some other attorneys from the firm doing some events, and I think it's a great, great resource to get more information on this. So if you watch this and you're kind of saying to yourself, well, hey, you know, all of this sounds really good. I looked over my documents. Some of this stuff I didn't quite see. What should I do now? I would highly encourage you to take us up on our offer to have a free, no obligation consultation with one of the lawyers at the firm, either me or one of the other lawyers. How do you do that? How do you take advantage of this? Right after this workshop ends, you're going to get an email that's going to provide you with a link, and all you need to do is click that link and you can schedule your free, no obligation consultation with us. All you need to do is make that appointment, and you need to show up. All of our appointments right now we're doing on phone consultation or video conference, and I've been doing this for about 8 or 9 weeks with my clients, and it's been going awesome, Jim. I know you've probably met with people too.
Love it.
Yeah, it's going really well. So I encourage all of you to take us up on that. Why wouldn't you? It's free, right? And I think what we're going to do before we kind of wrap it up here is let's open it up for one final Q&A. I know, Jim,
Well,
you've done a good job at answering people's questions.
There was one question in here from an anonymous attendee. Can you create, how do you add, no. I think it was, if you restate your trust, what happened, how does that affect real property? It's the terms of the last restated trust that stand. Anything that happened before is gone, right? So it's the last trust, the last iteration, the last amendment that controls the distribution of property.
So Jim, when someone does a restatement, do they need to retitle their property?
They should consider it, and that's a good opportunity to look at it. There's another question. If a trust is amended, must it be notarized? A trust must be amended. This is very important. A trust must be amended in the manner that the trust that is being amended says you have to amend a trust. So let me say this a slightly different way. Most trusts say that the person who creates a trust has the right, has the power to amend the trust, and an amendment must be in writing, signed by the grantor, the person creating the trust, and signed by the trustee. Oftentimes those are the same person. And sometimes it'll say acknowledged before a notary public, and sometimes it won't say acknowledged before a notary public. The problem if it is not acknowledged before a notary public, number one, you may have a problem with real estate because deeds require, real estate has to be notarized, just in California, that's as a blanket statement. Anything dealing with real estate, transferring real estate has to be notarized. Secondly, the whole point of notarization or acknowledgement before a notary public is that there is a state official, essentially, that says this person did in fact sign the documents. That's all the notary says. And if it's not notarized, you may have a problem. You may have a problem when it comes time to use that document. And Carol wrote a question. If my husband died 2 years ago and you have our trust, can I be sure it is all up to date now? Yes, you can be sure. So I'm sorry that you lost your husband, Carol. But we certainly, I think, make an appointment because there may be some questions we have to ask you on what happened in order to, because this trust covers a lot of factual situations, but I think reach out to us, set an appointment. We'll be happy to go over that with you. But you know, whenever you do lose a spouse, you should come into the lawyer's office or meet with the lawyer virtually or in the office, because death does change a lot of things. You know, I mean, just in general, but death does change a lot of things on an estate plan. And then Susan asked, my property is joint tenancy. When I amend it, can I change it to community property with survivorship? Yes, you can. That is something that you can do. And that's something that I think you should discuss with your lawyer. And then we have,
we have another question.
Let me just think. Yeah. And then we have problem with California notarization. Notarization can be moved from one document to another. Yeah, I mean, I think the question there is California notarization. You can kind of pull off the acknowledgement form and stick it on another document. When a notary notarizes a document, they write down what the document was that they notarized. But to your point is, can people fabricate pages and swap out pages? Yes. When our firm does an estate plan, we use a certain type of paper. We use a certain type of hole puncher, and we use a certain type of printer that has similar ink. So, and we handle so much paper, it's like being a bank teller and handling money. You can tell when someone swapped out a page. And so that's why swapping out pages doesn't work, because a judge is going to, do you think a judge handles a lot of paper? That's pretty much all they're handling all day. They're going to be able to go, wait a minute, what's going on here? It looks like a page was swapped out. All right, I think that's a wrap. Thank you so much. We will be sending out a follow-up email with a link, Jeff, a link to the recorded version of this. But thank you for coming in today, and have a great day.
Bye-bye, everybody.